Joining me now is our great friend, Melissa Murray. She's a professor of law at NYU, co-host of the Strict Scrutiny podcast, and an MSNBC legal analyst. Melissa, always intimidating to have these conversations about the law when you're going to be the guest. But it hit me really hard that how conservative justices, how do they not understand that if you sort of allow this is one of those things where you give an inch and they'll take a mile. This is bedrock.
No, I mean, for folks who talk about the history and tradition of constitutional law, this seems to beggar belief entirely. So one thing I want to emphasize is that you're exactly right. This is a shadow docket decision that was offered by the court. It stays that lower court injunction that would have prevented ICE agents from using racially profiling criteria to detain individuals. It does that temporarily while this case percolates. Just because it is temporary, though, doesn't mean it's not grave, as you say. Like, it could be a long time before this case goes up to the court again for a final decision on this question.
And will that be heard on its merits with arguments and all of this?
Ostensibly, if it goes all the way up there. But I want to just emphasize a couple of things. It allows for the moment, and the moment can actually be quite large, the federal government to use these criteria, whether you speak Spanish, whether you work a low-wage job, all of these things can continue to be used to bring people in as reasonable suspicion of being here unlawfully. And again, as you say, those ICE sweeps are just that. They sweep in broad swaths of people, including individuals who are here lawfully and individuals who are citizens. Justice Kavanaugh offers in his concurrence some inkling of what the court may have been fighting about. As you say, on the shadow docket, there is no decision. We don't know, and the court didn't offer one here. We just have this concurrence from Justice Kavanaugh and this dissent from Justice Sotomayor. One of the things that Justice Kavanaugh emphasized in his concurrence was that they're not really sure if the challengers here have standing to bring this case. So you can't get into federal court to bring your case unless you can show that you have been injured by the defendant's actions. And one of the things Justice Kavanaugh says here is that by asking for injunctive relief, prospective relief, to stop the government from doing this going forward, the challengers have to show that they are going to be swept up unlawfully, even though they are citizens or lawful residents of the United States. And they can't actually show that. There's no guarantee that they are actually going to be swept up in this. I mean, I guess that is technically right, but it does beggar belief given the scope and sweep of these ICE raids. And so, that means going forward that if you want to have a clear chance of being able to challenge the use of these criteria in court, you're going to have to show that you were unlawfully detained and swept up because of these characters. So it's all going to be kind of after the fact justice. And I want to make clear, that sounds easy. It's not really easy because these are not criminal cases. You're not guaranteed a lawyer. You're going to have to go get a lawyer. You're going to have to mount this case. That's going to be incredibly hard for individuals who may actually be low-wage workers who don't have a lot of disposable income and maybe don't even have the appetite to challenge the government because they're scared. So one of the things this decision does is not only license the use of these criteria, it actually makes it harder for individuals to go forward and challenge it. And so that means we may not see a lot of cases going forward unless people can band together, get the kind of pro bono interest that they need in order to move forward. So I just want to make that this makes it really hard.
This level of detail is really important. I guess that begs the question, if I get swept up in a raid and then released and there's no particular damage, except the fact that I read in my Constitution that you're not actually supposed to do that, how does that play out?
Well, so again, Justice Kavanaugh's concurrence offers some glimpse of what the majority thinks about these kinds of harms, which may be dignitary harms, but quite profound. Justice Kavanaugh notes, and again, this seems to be slightly optimistic, maybe a little bit of wishful thinking, that when the government detains someone who is here lawfully or who is a U.S. citizen, the detention is brief. It is going to be brief. He doesn't define what he means by brief, as you have said in your reporting. Sometimes people are detained for 3 days. That doesn't seem brief to me when you're not supposed to be there in the first place. And so, it does seem like Justice Kavanaugh is kind of playing fast and loose with other people's lives when he's talking about, it's just a brief detention. It's a mere inconvenience for these individuals who are just sort of casualties of a broader enforcement power of the government that we are going to credit. And, there have been lots of Supreme Court decisions over our history where the court has been faced with whether or not they need to do something for efficiency or expediency, and whether they have to abide by people's rights. And they've always come down in favor of, like, there are higher values than efficiency. We have to respect the dignity, the rights of other people. This decision seems to blow that out of the water.
Why would this, or maybe it has, is this meeting with resistance from conservative judges? Because these are conservative concepts, right? The idea that the government stops here. You don't, your larger interest does not outweigh my interest of privacy and protection.
So we haven't seen any judges speaking out. We did see last week judges speaking to Lawrence Hurley of NBC News just about how difficult it is to rule on these cases in light of the shadow docket landscape, where the court is issuing these rulings, not giving a lot of explanation, and then chastising lower courts for not following their decisions on the shadow docket. So we haven't heard anything particular about this case. I will say that the lower court judge who issued this injunction is very careful. I mean, this is not someone who just is a rogue judge. None of these judges are rogue judges. But the fact that the court keeps issuing these decisions, not giving a lot of explanation, just saying, like, no, this lower court judge was wrong, feeds that idea that these lower court judges are just going out and doing their own thing, which is really not the case.
Yes. I'm back with Melissa Murray. Melissa, fundamentally, there are lots of details, and I don't know whether the Fourth Amendment as a protection is more complicated than the Third or the Second or the First or the Fifth. But I, as a non-constitutional scholar, was really interested in clarity about this, because it's a fundamental protection that I believe to be important in America, right? That they can't just roll you up because of what they think. And all my TV cop legal shows seem to depend on that, right? Where are we in that larger effort?
So, again, I thought your explanation of just the animating principles behind the Constitution were really important. I mean, this is a document that's intended to diffuse government power across the three branches of the federal government and between the federal government and the states, so that no single branch and no single entity has too much power and can become tyrannical. In addition, almost from the start, we passed these Bill of Rights amendments because we want extra added protections for individual rights, meaning that the federal government can't do these things like keep soldiers in your house or detain you without reasonable suspicion that you have done something wrong. It's all about preventing the prospect of a government that is tyrannical. Right now, we are, I think, moving dangerously close, frog boiling territory into the real tyranny here. I mean, the idea that individuals would be required to carry their passports on them in order to establish that they are citizens and lawfully here. This is
That's
stuff
got
that
some ugly
this is in
things,
the very recent past. I mean, these are the kinds of things we saw in Europe during the period preceding World War II. So this isn't an idle threat. And no one is saying that the government is without the lawful authority to do immigration enforcement,
or to arrest people on lawful suspicion.
It's how you do it, though, right? You can't sweep so broadly. I mean, there is a Supreme Court case, Korematsu, in the wake of Pearl Harbor. The United States decided to issue an executive order that essentially rounded up individuals of Japanese descent living on the West Coast and to intern them. And the Supreme Court blessed this. A number of justices in the minority, among them Frank Murphy from Michigan, said, wait a minute, we have higher values than this. Like, we cannot be so fixated on national security that we lose sight of the individual rights that we are trampling. We can't be so over-inclusive and just round up everyone. We actually have to go in and figure out who the threats are. And that's, I think, the same kind of principle that should be at work here. This is essentially the point of Justice Sotomayor's dissent. Figure out who are the individuals who are
That's
here
the hard work of
unlawfully.
governing, right?
It's hard, but it's your job.
Right.
That's your job. You had one job.
It's 2025. We can figure this out. Talk to me about what Justice Kavanaugh implied, that if the interest here is avoiding being arrested or in breaking the law, I mean, couldn't you apply that to everything in the Constitution? That protections for people are protections for people. If your motivation is to break the law and use constitutional protections, there should be a mechanism to deal with that.
No, again, again, this is all, I think, in how you frame the interest. I mean, he's framed it as the individual's interest in being law-breaking.
Yes.
You could also frame it as an individual interest in personal security, in dignity. Yes, the government has an interest in finding those who are breaking the law and punishing them, but they also have an interest in not doing that to people who are not breaking the law. I mean, that's kind of basic stuff. And we have a sort of broader principle in the Anglo-American legal tradition that it is better for 100 guilty men to go free than to have one single innocent person unjustly punished for something he did not do.